social media has given this issue both a platform and an opportunity to literally go viral, so that when there is a complaint, when there is an allegation, when there is a story, it has a way of getting out into our conscious very, very quickly. However, the fact that these things are public so easily and so quickly also creates essentially a record for what amounts to the employer's investigation of these issues, and much of what is contained in Facebook posts and other types of social media communications can constitute evidence and be used to support ultimately an investigation and determination about the relative merits of the claims and defenses that might be made in one of these cases. I want to start this morning with just a little bit of an anecdote that I think sort of sets the stage for some of the themes that I want to have you leave here with today. Shortly after the Harvey Weinstein story broke, I was asked by a long-term client to consider an allegation that had been made by a group of female assembly line workers in a fairly large area factory. Most of these women were of Eastern European descent. They reported to two job foremen who had an office separate from the assembly area. And those two gentlemen were both English-speaking and native to this country. The employer, it was a privately owned company run by one individual, was incensed by these allegations and felt betrayed by these workers, and was trying to convince me that these people were all slackers and that they're all in the process of trying to cover their tracks to avoid termination, and that this claim is completely contrived. So we had that telephone conversation, and I had suggested to him that a little preliminary boots on the ground work by me would at least allow me to understand the lay of the land, literally and figuratively. I wasn't planning on conducting any specific interviews in this first go-round, but I needed to understand how the shop was set up and who worked where and who communicated with who and what was the chain of command, direct reports and subordinates, etc. So I had asked my client to just sort of leave me be. I didn't want him to follow me around. So the first place I decided to go was into the foreman's office. Now, keep in mind that the essential allegations that had been made by these women is that the foreman had put them in uncomfortable situations, both physically and emotionally, by the nature of their communications. Although these women often spoke broken English, they had a sense that the two foremen were talking about them in a sexually suggestive way in English in an effort to make sure that they didn't fully understand it. There were some incidents of physical contact, and a lot of this took place in the actual office setting. The foreman would bring a particular worker in there to engage in some sort of conversation, and the women felt uncomfortable. And this was a very consistent theme. So I walked into the foreman's offices, the separate desks facing one another, and behind each desk, what do you think I saw? Naked women calendar. You got it. You couldn't be any more accurate. It was the calendar that we've all seen in, I don't know, the auto repair shop or in a factory or a foundry somewhere. And the point of my telling you that story is not to assess guilt or to use that one particular calendar as proof positive that these guys were harassers, but to show you that the employer was oblivious to the issue. They didn't understand their own place. They didn't understand various people's roles in it. They were not particularly sensitive to the concerns and the objective reactions and subjective reactions of those women who were subordinate to their male superiors. The point of the story is essentially that what we need to do in this environment today is be aware be communicative, and be concerned. And if an employer is able to do all three of those things, they are well on their way, I think, to avoiding any legal liability and or catastrophe relating to these types of claims. It's certainly not a complete shield, but you need to understand the world in which we live. You need to make an accurate assessment of your own workplace and your own workforce. You need to be open to dialogue with those who work for you and engage in active and honest communication with those people. And you need to express some degree of concern or empathy for this issue because it's not going away, it's very real, and it's gone on for far too long. Let's start off just briefly. In the materials I provided to you this morning, there is the sexual harassment posting that employers are supposed to put in a conspicuous place in their operation. That was crafted by the Commission on Human Rights and Opportunities here in Connecticut and does its best to synthesize and summarize both the Connecticut statute and the federal statute that defines what sexual harassment is. And those definitions are not all-encompassing. Certainly the law has evolved in that it has viewed other conduct that perhaps extends or relates to these definitions to meet the standard definition of sexual harassment. It's important that we talk, I think, today about what are an employer's obligations when confronted with these issues. Because typically the calls that I get, and certainly the calls that you folks probably deal with, are what do we do legally, factually, from a document perspective, in response to such a claim? What are the employer's obligations? And oftentimes, the status of the harasser and the nature of the relationship will govern what the employer's responsibilities are. And what I mean by that is that if you have a relationship where the alleged harasser is a supervisor, and as a result of the interaction and or behavior, that supervisor has taken adverse, tangible action against the employee as a result of this relationship, you have a problem on your hands that in virtually all respects the employer owns. That meets sort of the hallmark definition of a sexual harassment case, sort of this quid pro quo sexual harassment, meaning that unless you play ball with the relationship rules that I as the supervisor are trying to establish here that have nothing to do with our working relationship, I'm going to make your employment status worse. And that might mean termination, it might mean demotion, it might just mean making that person uncomfortable in a group setting such that it affects their ability to do their job or their overall job satisfaction and performance. The cases that become a little grayer are when there is essentially a coworker to coworker contention of sexual harassment. There, the employer's obligations are to recognize, investigate, and where necessary, remediate. And we're going to talk a little bit about what an investigation entails, meaning a good investigation entails, and how to document the steps of that investigation, how to communicate during the investigation as well as the results of the investigation. But it is not a situation where there is the same sort of strict liability in a coworker to coworker situation where there is not an adverse employment action brought by the supervising employee against the subordinate employee. Let's talk a little bit about, again, why this is all happening. And we mentioned social media as a sort of a wellspring for these types of claims. But since, I would say 2015 or so, there has been a lot of statistical surveys and studies done with regard to this subject. And what do you think the percentage is of women in the workforce who contend they have been subjected to sexual harassment of some kind is? Now, again, sexual harassment based on their own interpretation as to what that is. Does anybody want to guess as to what the percentage is?
95%.
Not quite that high. 75% is the number. And how many of that 75% have actually reported it?
Very low. 2%.
No, not quite that low, but it's in the teens. It's in the teens. So I think the proliferation of this issue via social media is in large part because there is a sense among those who have been harassed that there's now some commonality, that they have shared experiences with others out there, and it is now okay to come forward, whereas before there were grave concerns about my employment status, how people would perceive me if I was to complain about this issue, and clearly monetary concerns, that if I were to bring this issue to the attention of my employer and it were to affect my track within the place of employment, and I don't get bonuses, or I don't advance, or God forbid I get terminated, there's an actual financial ramification to me. So I think this heightened sensitivity generated by social media and by a lot of press stories about Cosby, Matt Lauer, Harvey Weinstein, countless other actors in Hollywood and those in the broadcast industry, has promoted a solidarity or a sense of commonality amongst those who have been victimized in the past. There's a problem embedded in all of that, and that is our perception as to what is reasonable and what is reasonable behavior is polarizing. Many people feel that the approach to this thing is all conduct is worthy of investigation, men are bad, they're doing this on a repeated basis, the pendulum swings back, and others are hearing all of these stories and they're saying, this is a witch hunt, this is all unfair, women aren't to be trusted, these stories aren't believable. So when you have one of these cases that it evolves to the point where you have to consider a jury, for example. Who do I select as my juror in this case? Because Connecticut has a process of individual jury selection. What am I looking for in terms of someone's sense of what is reasonable under these circumstances? And what is inappropriate? What is offensive? All of those standards are really tempered by our collective experience, which is affected by what information is available to us out in the media and in the marketplace. Another byproduct of this scenario and these circumstances is that typically politicians react to these stories just as quickly as lawyers do. And politicians are often well-minded in proposing legislation that will redress these circumstances quickly and provide greater relief to those people who have been victimized, put certain onuses on the employer, but oftentimes legislation isn't well crafted and it isn't well written, and it creates unintended circumstances and unintended consequences to employers. And case in point is the proposed legislation that I've included in your material, which I don't obviously expect you all to go home tonight and read and commit to memory, but it's an indication of what our legislature was contemplating, and there were two competing bills, both the House and the Senate bills, and ultimately, in the last session, neither bill was even put to a vote. But there is a change coming, and I would think that the very nature of ultimately successful legislation will include required training for virtually all employers. This particular bill contemplated reducing the number of employees to 3 before you had to engage in some sort of training. Now again, the legislation did not do a very good job at defining what does training really mean. Does it mean that you have to go get someone like you folks and bring them on site and conduct a workshop? Or is it okay to download a webinar and just have your employees sit in a conference room and watch it? What are the various reporting requirements once you've completed this training? What happens when a new employee comes into the workplace? Do I have to do it all over again? What if I'm changing employees on a fairly regular basis? That could cost me a fortune if I have to repeat the training that I've conducted for these 6 for the next batch of 3 or 4 that I bring in. So again, politicians were quick to raise their hand and promote their own agenda in the media in order to mollify voters and potential voters, but they weren't necessarily all that adept at crafting legislation that really addressed the issue accurately and was realistic given the already onerous burdens on most small employers. Another thing that they contemplated doing with this legislation that I think is coming is they're going to change the available damages to an injured complainant in these cases and up the ante for employers in terms of their exposure. There will now be the prospect of additional attorney's fees and costs associated with these claims being assessed to the successful plaintiff and against the unsuccessful employer. There may well be more available punitive damages than have ever been available before to punish the offending behavior and make sure that the employer this time understands what it did wrong and never contemplates ever doing it again. In addition, there will likely be an elimination of certain defenses that the employer might have or an elongation of the claims period. Does anybody know right now, if you bring a claim of sexual harassment to the CHRO, how long you have to do so before an event of harassment? Does anybody have an idea as to what the time period is? Right now it's 180 days. It's 6 months from the offending conduct. The proposed legislation was going to extend that to 3 years. And I know in New York State, in terms of a civil action, meaning bringing a lawsuit in Superior Court or in federal court, there was a contemplation of eliminating completely any statute of limitations, almost like they do with claims of minor children brought against adults who engage in sexually inappropriate behavior or sexual assault. So you could have essentially a limitless look-back period here being at least contemplated by the state legislature in proposed new legislation. And I frankly don't think that that's going to be particularly healthy or beneficial to most of our clients to have to process and deal with. So what do we do as employers given the world in which we're now operating? I have a nice little acronym that I like to tell my employer clients that help them remember what I would describe as their responsibilities as employers in the world today. And the acronym is RACE, R-A-C-E. The R is recognize the world in which we live. Things have changed. I'm sure all of us have dealt with people who describe themselves as old school. I'm old school. Well, unfortunately, old school has a lot of views of the relationship between men and women, the relationship between gay people, the relationship of adults to children, in a way that, in our view today, we would consider inappropriate, odd, offensive, you name it. And if this person who describes themselves as old school is unwilling to change or be educated as to what is considered new school, that person or entity is shaping themselves up, I would suggest, for a potential problem. So you've got to be aware that times have changed And this issue is in the forefront today, and it is part of our national, if not international, dialogue. So that's the R. The A is assess your own workplace culture. You got to take a candid look at your methods of operation, your relationships and your communications, as well as your various practices, in order to decide whether or not change is appropriate given the circumstances. Many of these cases involve after-work activities, workplace travel, and certain policies that are either followed or not followed, and I'll describe what I mean by that in just a second. The scenario most commonplace with workplace travel is not always the obvious one where a supervisor brings along a subordinate and they have a couple of drinks and the supervisor pressures that subordinate to come back to the hotel room. It might often just be the whole culture associated with workplace travel where the environment is demeaning or inappropriate for a woman to take part in. I can remember an example in one of my cases where the routine sales trip that the big regional sales manager would bring along his female subordinates on included going to the steakhouse with the customer and then going to the strip joint afterwards. And there was no overt pressure on the female subordinate to actually set foot in the house of ill repute. But the message was, I'm going out with the boys, and you better learn to become a part of this, or you're not going to develop the relationships that you need with these guys in order to promote our business and for you to advance and earn additional commission. It wasn't verbalized like that, but the message was clear. This is the activity that we engage in when we go on a customer sales trip. And the employer, again, seemed to think that the answer to that was, well, I don't have legal liability because he wasn't making them come along to the strip joint. Well, you still got a problem, potentially, in terms of compliance with the law, that if you want to be an ostrich about, I can guarantee you, if not today, tomorrow, somebody's going to say, I didn't get promoted or I didn't become the regional sales manager because I wouldn't be engaged in that deplorable behavior. And this person was trying to send me a message all along that if I didn't do that, I wasn't going to advance. So there's a classic example of a office activity that's sort of embedded in the nature of the work that this company did, that the employer seemed to think was not problematic because there wasn't sort of a direct cause and effect where supervisor forced subordinate to do something that by all definitions I think we would consider to be offensive. And it's not just travel, it's other workplace activities that often involve drinking out of the office, or maybe even in the office, where the standard end of the week procedure would be to go out to a local bar and the company picks up the tab for rounds of drinks, and oftentimes people in that environment don't feel comfortable or are made to feel uncomfortable because alcohol has a way of often lowering people's inhibitions. Things that ordinarily would be held in check or would not be said all of a sudden come out. And again, people feel as though I'm obligated in some form or another to go and participate in this activity, yet it doesn't make me feel comfortable. And I'm not suggesting that we need to eliminate all of these activities. What I'm suggesting is we need to be aware of the circumstances that we are either creating directly or overtly condoning by allowing supervisors to organize these things and direct the activity and picking up the tab for it. I mean, we as employers can't necessarily babysit everybody in the workplace and say, well, you two can't go out for drinks on a Friday afternoon after work. That's a very different scenario than when we organize it, or when the vice president or regional manager says, hey, it's Friday, 5 o'clock, guess what? We're all going to the local bar, and that's every Friday's activity. That's a different scenario. Excuse me. One of the other things that often lead to problems or potential problems is not observing what we like to generally refer to as open door policies. In my office, it is very, very unusual that any person would come into my office and the door would be closed for a closed door meeting. We've just never been comfortable with that. We don't feel that it's necessary. Our offices are configured in such a way that we're not necessarily projecting out into the space or being disruptive to others. But I think that there are many other work environments where come on in and close the door is really the norm, not the exception. And there are people who just don't feel comfortable being in closed, confined spaces with people of the opposite sex with no one to supervise or police in the event that there are conversations or conduct that exacerbate that person's feeling of discomfort. So again, I'm not trying to create rules here that are hard and fast that suggest that we can never close the door in the office space, but be mindful of how it makes the subordinate feel, or consider whether or not someone of the same sex should also be brought into that environment so that there is essentially a buffer where the person sitting across the desk from you or from one of your people would be made to feel more comfortable in that environment and at least feel as though there is an ally or an observer to address or objectively what went on in that space and what went on during the course of that communication. Questions about any of that? So that's my acronym is RACE, R-A-C-E. The C is commit to change after you've made an honest assessment. The example I gave to you at the start this morning of the employer who just probably had never bothered to go down into the foreman's offices and see the calendars. If he was so steadfast in his belief that he was doing everything that he should be doing as an employer, that he was pounding his fist on the table about how dare this woman bring this claim, I'm doing everything that I can now honestly go back to his office and say, no, you're not. No, you're not. You haven't even ventured down into the workspace for long enough to recognize that there are calendars on the walls of these foremen that by any standard would be considered offensive to most people. So if you want to tell me that you're doing everything that you can, and I'm identifying for you a clear problem, you need to commit to change. You need to sit down with those foremen and say, in this environment, we're not putting up that kind of calendar. You want to keep a calendar, there's plenty of calendars out there that don't have pictures of women in bikinis washing cars on them, or worse. So commitment to change is the C in RACE. And the E, of course, is educate yourself and your people. Now, we've talked about training, and I know that you've been involved in doing some training for employers, but we don't really have a great sense as to exactly how the training should be conducted and what should be its content. I do have a couple of suggestions about the training that I think are worthwhile noting. I'm a firm believer that live training is way more beneficial than some sort of webinar or online training. I don't think you get the same level of engagement in a webinar or online training that you do in face-to-face. If the whole point of this is to roundtable discussion and have open and active dialogue, well, you're not getting that from a computer screen that you're watching. Unless there are rare circumstances. I mean, I've certainly seen webinars that can be made interactive. But the whole process of sort of getting yourself in the queue and loading up a question that you hope that the presenter actually gets to and answer is not the same thing as us sitting around this table and discussing these issues. And I also think that the open forum setting is a critical element to good training. There may be people who feel very strongly about a particular issue in the office, and there are people on the other side of the table who say, wait a minute, that's nuts, that's crazy. I'm not doing anything wrong. What are you suggesting about me? That dialogue is actually healthy. It's not counterproductive. It's important that people share with each other openly a sense of what's bothersome to them, and that the persons who are being, I don't want to say accused necessarily, but who those suggest are engaging in things that make others feel uncomfortable, understand that perspective and vice versa. So I like the idea of bringing in a facilitator or a presenter, getting people around the table and engaging in open and active dialogue. A third point I would make is I don't view the idea of training as limited to just supervisors. These issues aren't all supervisor on employee or supervisor on subordinate. These are often problems between coworkers where a relationship might start and all of a sudden it gets a little out of hand. I'm dealing with one right now where there was some flirting, there were some drinks after work, there was a date or two, and then 3 weeks later, after there was no date, there was the pornographic picture text of a body part that now is on a coworker's phone, which she then brings to her HR person and says, this relationship, which I voluntarily engaged in and started, has now gotten out of hand. You need to do something about this. So it's important that we not view these training sessions as us gathering the troops and closing ranks in an effort to avoid legal liability. I like to think that what we're doing in these training sessions is trying to do our best to understand the concerns and comply with the law as best we can. And yes, if a natural byproduct of that is reducing or eliminating our legal liability, that's all great. But if you go into the training with the idea that all I really want to do is get my supervisors to know what's bad to make sure I don't get sued, I think you're missing the point. There's more to this issue than that. It's about creating a culture where people feel safe, where people feel that their employer will stand up for them in the event that they don't feel safe, and for employees to feel as though they can freely and openly communicate the concerns that they have amongst themselves and up the food chain, if you will. One of the other things to try to accomplish in these meetings is to create a process by which this communication can take place. What do, many employees who bring these claims often say was an impediment to bringing their case forward? Does anybody have a guess about that? Yes?
They're threatened with their job.
That's certainly a concern that they have, but there's another reason that is more
They're
procedural.
by the rest of the department. I mean, I worked with the girl
Yeah.
that it happened to, and it was pathetic.
Yeah. They certainly have those fears, but they also often don't even know what the process is of bringing a complaint because you never provided them with direction as to how to go about doing that. You never said that this is how we go about communicating a claim of sexual, this is who you'd go to. And if that person is in fact the person who's harassing you, here's where else you can go. Most employees who don't bring these claims or feel that they couldn't bring these claims are not just fearful of the consequences to them, they just don't know how to go about doing it.
They're
And they don't feel that you have entrusted to them a chain of command or a means of getting these things out into the open and investigating them.
Well, I think
One last thing in terms of what I think we need to do as employers. I gave you the RACE acronym and a lot of information, I think, about the various trainings that I think are available and successful. But we also ought to be looking at all of our written communications to employees and to the outside world to assure that we're communicating the right message. If you have an employee handbook or a manual, there should be an affirmative statement against sexual harassment and a reference to the procedure for bringing complaints to the attention of management. Obviously, this posting is required by law to be in a conspicuous place within the place of operation. I go one step further and make it part of any employment manual or handbook so that each employee, assuming that they actually keep the manual or handbook, has it at the ready and they don't have to go looking in the coffee room as to where you hid the poster about what constitutes sexual harassment. But I also think it's effective to have some sort of tagline in written communications that you might send out to customers or to vendors or web pages that take a strong stance on the subject. And just the same way that you'll see on many websites that we're an equal opportunity employer, I don't think it's a bad idea to say we're concerned about the workplace environment. We look to provide safety at all levels, physical and emotional, for the people who come in contact with our operation. And we strongly discourage behavior that could constitute sexual harassment and take all claims regarding such seriously. I'm just free-forming it, but I'm not citing verbatim from any one particular statement that I've crafted for anybody, but I think that notion ought to be communicated to many who you come in contact with in your written communications. And I think, God forbid, there's ever a legal claim brought against you, I think it's compelling to a judge or jury or even a CHRO investigator that you don't just say you take these things seriously, you've actually done something about it. Okay, agenda item 14 today is what are the incidents of sexual harassment that are making you all uncomfortable? If you just have an open forum item, it will often lead to these kinds of discussions where you can get a sense that maybe a subsequent meeting with that particular paralegal and the assigning attorney might make that para or administrative assistant feel more comfortable the next time client so-and-so comes in. Let's talk about how to conduct an investigation. And I think this conversation leads to one of my overriding points about this segment of the outline, and that is be very wary of reacting without full awareness of all of the facts. And what I mean by that is, the sort of classic knee-jerk reaction that my client's story early on this morning revealed is insufficient. You can't just pound on the table in the face of these claims and say, well, we're doing everything right. You still have a responsibility to hear what has been said and to educate yourself as to all of the necessary facts before you draw the conclusions. So who do we get to do these investigations? That's really almost decision number one. You may live and work in a structure, in an environment that's very structured so that it's clear that any claim of sexual harassment would be conducted by the HR department. That may be your setup. If not, you've got to decide whether the person who's in charge of your HR is the right person to conduct that investigation. Do you want to consider using inside counsel, meaning if you're, again, in an environment big enough where you have a house lawyer on staff, do you want to do you want to have that person conduct the investigation, or do you want to consider using somebody like you, Barbara, or me, as a complete outsider to conduct the investigation? And there's no real magic to it other than you need to pick the person with the right skill set to conduct the investigation that's most appropriate and likely to lead to a successful resolution. And what I mean by that is, if your HR person happens to be abrasive or non-communicative or difficult, and the employee's complaint is in essence that they're not being listened to or heard about these various complaints of sexual harassment, then you may have just created a dynamic that's destined to fail. And you may want to look at that circumstance and say, I think I want to pick somebody sort of outside of the loop to look at this more objectively. I've had circumstances where the HR person becomes very, very defensive about the structure that they've created. And they're like, no, this can't be happening under my watch, right? I mean, I'm the HR director. I mean, I've set this up to make sure that these things don't happen and these accusations don't get made. And obviously, from that conversation alone, you know that person is not going to be objective in conducting the investigation or willing to listen with an open mind. So that might be an example where you say, I'm not going to use the HR department this time. I'm going to pick outside counsel or use inside counsel. In the event that these cases progress to the point where there's actually a lawsuit brought, there is another consideration in terms of conducting the investigation, and that is what is maintained within the attorney-client privilege. And oftentimes, if you hire an outside person to come in and conduct the investigation, particularly if that person's not a lawyer, you're not going to retain any privilege based on the predicate facts, findings, and conclusions of that person. So I would often encourage my employers in making the decision as to who to conduct the investigation to at least communicate with me as their counsel to decide, well, do we have a concern long-term here about the accessibility of the information that this investigation produces, and is it going to retain the status of attorney-client privilege in certain circumstances? One of the other issues to think about in terms of conducting the investigation is not just who, but what is it that you're looking at? Obviously, sort of testimonial communication is going to be part of every one of these. But where am I going to look at for the documents that support or don't support these contentions? All I can say, folks, is text and emails are where it's at. All of these cases almost always can be ferreted out, and some sort of objective truth can emerge from a chronological written history of communication. The example that I used before about the relationship that started as a flirtatious one in the workplace and then led to the pornographic text. There is a day-by-day and often hour-by-hour chain of communication between these two people. And just to tell you a little bit more about that story, ultimately when the pornographic picture was presented to the HR department did conduct a thorough investigation with written notes of the interviews that she conducted with the applicable parties. She gathered all of the appropriate internal and external documentation, and she reached an appropriate conclusion that although she couldn't control their relationship outside of the office, she could certainly control it inside of the office, and she permanently segregated the two so that they had no professional contact. She changed the shift of one and the shift of the other so that never the two shall meet, and they no longer had any business reason to be communicating with one another. Ultimately, the employee who sent the pornographic picture chose not to stop, and he continued to pester this woman, and she felt that we didn't do enough to stop that, even though it was not on work time that he was conducting these activities, and felt that we should have fired him, and we disagreed, and ultimately there is now a pending lawsuit over this subject. So you can see how even when you endeavor to do things right and do the right things, that it's not this perfect insular shield that can protect us from any and all claims. But the answers about who said what to who are usually out there if you can drill down on email and text communications. And one of the things that I would tell my clients to do would typically be to hold or freeze electronic communications that are between the two principal participants in this problem, so that nobody goes in and starts the process of deletion. Because that, I can tell you from experience, can really get the employer in trouble when the accused supervisor, even unbeknownst to upper management, on company time goes in on the company computer and starts to delete files and delete communications. Didn't do a thorough enough job in the one instance that I'm describing, so it was clear that he was deleting, he just didn't delete everything that he wanted to delete, and it then made for a very bad record for the employer that this guy was not only likely doing what he had been accused of doing, but he was covering his tracks. So there's something called an electronic preservation or an electronic hold that oftentimes is demanded by a plaintiff who's represented by an attorney of an employer that has to be respected, or you really run some real risks in a courtroom. I try to be proactive, and when one of these issues comes to the fore, say, okay, this is the communication, and these are the systems that we're going to put a hold on, and that may often include gathering company-issued phones, and just say, look, I'm taking this phone and I'm gonna give it over to our IT people, and they're gonna download all the communication. So all your personal stuff that's on there, it's gonna be exposed and part of this investigation. So, yeah, is everybody aware that there is an electronic monitoring statute out there that governs such things as video surveillance of the parking lots, or employers logging on via password to employees' laptops and monitoring the activity that's going on. It's permissible under the law in Connecticut and in most other states, but there's a required notice and posting under Title 31 of Connecticut law that must be provided before you engage in that activity. So again, good way to handle it, make it part of your employee manual as an attachment so that everybody gets it, and when they get their manual, they sign an acknowledgement of receipt of the manual and all the attachments, so that they can never say, oh, I never got the notice, and it's not posted anywhere in the work environment. That's the best sort of prophylactic approach that you can take on that issue. But yeah, I'd like to remind our employees all the time, both orally and in updates to our manual and in staff meetings, that I don't want to quite put it that Big Brother's watching, but just understand that we have that right and we exercise that right. So if you're going to engage in communications that you and I both know you probably shouldn't be, and that might just be, looking at inappropriate websites during the course of the workday. I'm not necessarily suggesting that it's all, bad or salacious activity. It's just work. It's just stuff that shouldn't be done on work time, that they're aware that, we have that right and can do so. I guess ultimately what we care about is the conclusions of these investigations, and how we go about communicating that. What we have an obligation to do as employers is to take appropriate remedial action. And there's no specific definition in the law, based on cause and effect. There's no statute that says, well, if the allegation is this, you must do this. We still have lots of discretion as employers to do what we think will remedy the situation. That's why I think it's important during the course of the investigation, if you're communicating with the plaintiff, to understand what they think is an appropriate remediation. And in the case that I was just telling you about, When HR communicated to the complainant that we were changing the schedules of the two infected employees so that they weren't going to interact, her response was, gee, that's great. That was just what I was hoping for. I just don't want to see Carlos on a regular basis anymore. So we have, some record of the fact that what we proposed as remediation was acceptable to her at the time. So I think if you're trying to gauge what is appropriate redress based on a complaint that you investigate and you conclude that there was some action that you want to change and redress, that you get the input of those most affected by it. That obviously leads to a question of what do we do when our conclusion is that there's no merit to this claim. Again, I've had employer clients pound on the table. I want that person fired. This was a false claim, and it cost me all this money, and I had to deal with lawyers constantly over this issue, and she's a liar. I want to get rid of her. Very rarely, if ever, in the 20-plus years that I've been doing a big part of this in my practice, did I see a claim that was patently false and that was motivated by malice or just pure recklessness, that somebody was out to get somebody. I mean, we hear about those stories all the time where this event just never happened and they just wanted this person fired because they didn't like them. I just haven't experienced that. I think what there often is a difference in perception of certain behavior, or perhaps an over-the-top reaction to certain behavior. There wasn't a falsity in terms of the allegations. There was just a difference in perception of the behavior that led to a conclusion that what A did wasn't necessarily bad enough to do anything about, and the conclusion of the investigation would be that there is no remedial action. I think that if you're going to treat people who bring claims that you ultimately conclude don't warrant remedial action as bad apples and choose to terminate them, all you're doing is buying a different lawsuit, right? Somebody's going to say, they gave me the means of complaining about this. I did it in good faith. They reached an opposite conclusion to the one that I liked, and now I get fired? That's just going to be another lawsuit, one of which I think probably has a fair degree of merit. I haven't actually seen that case or participated in it, but I think that's the wrong approach unless you have really, really concrete evidence that the complainant's behavior and complaint was motivated by malice or a willful or reckless desire to harm somebody. I do think that's a different circumstance. I mean, if you have some email that complainant sent to coworker, hey, we both really hated supervisor so-and-so, and I just stuck it to him by bringing up this claim about what he did at the restaurant recently. You and I both know that's not true, ha, 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 kind of thing. I mean, that's a different kettle of fish, I suspect, in terms of whether or not you might have a sound basis for terminating somebody for bringing a false complaint. A whole range of remedies that the plaintiff can request, one of which is reinstatement if they've been terminated. Certainly compensatory damages, so that if the claim is, I didn't get the promotion because I didn't go to the strip joint with the regional sales manager, and had I gotten that promotion over the last 3 years, the bonuses that were paid to those people were 60 grand a year times 3, that's 180 grand plus interest. In addition, those guys all got company cars and better health insurance or a bigger contribution to their 401k. I mean, what plaintiffs' lawyers do with the assistance often of expert witnesses is evaluate the economic injury that result from the adverse employment action, be it termination or be it a loss of opportunity within the organization. So some people want reinstatement. That doesn't happen all that often. I don't think most people want to be subjected to a bad environment and then say, yeah, you know what, I'm dying to go back there. Most of what they say is, I want them to be penalized, and I want my money that I would have been entitled to, and I kind of want to have my record purged, if you will. So if you're thinking about non-litigious solutions to these things, meaning settlements, oftentimes one of the first things that's on the table is, I want a reference that washes this termination from my record so I have the opportunity to get gainful employment in my chosen field on a going forward basis. I don't want this termination to be a stain on my work record. I want something, not your promise that you're going to answer the call when my next employer calls and then tell them all the bad things that you think about me. I want a letter of reference that I can take and hand to the next HR person who's interviewing me. Now, and it did. I got off track. Reinstatement, compensatory damages, attorney's fees, punitive damages, and in some instances, emotional distress damages. Again, I think in our common market discussion of these cases, the whole notion of emotional distress has kind of gotten tortured to be something other than what it is. The law recognizes emotional distress that manifests itself in a particular physical injury, usually substantiated by a treating physician. And I think most people think that, oh, everybody who brings one of these cases thinks that they're going to get emotional distress damages. The proof of those damages is not quite as simple as most people seem to think it is. And not every one of these cases results in an award of emotional distress damages. So if a plaintiff or a complainant comes to a lawyer and says, well, I want emotional distress damages, the first question that a good one would ask is, well, A, what distress have you suffered? Who have you been treating with? What's the diagnosis, prognosis? What medications are you taking? And really develop those damages, no different than the effort that would be invested in developing the compensatory damages, in calculating the lost wages, the lost benefits, et cetera. So that's the range of the damage exposure that employers have. And obviously, the non-economic damages are just the loss of productivity time that these cases involve is staggering. You get into the nitty-gritty of trial preparation for one of these cases, and I maintain that if I'm going to select a jury, you're going with me, and you're going to be there every day, because I want the jury to see that you care about this case, and I want them to recognize who you are and that you're invested and interested in this. And it might take 2 weeks to pick a jury in some complicated cases, and imagine taking a senior management person out of the mix for 2 weeks to sit by my side while I ask essentially the same series of questions of 20 people who are potentially going to be in our jury box. That's a lot of downtime, and you run the math on that, and that can be a number that makes the damage claim pale in comparison. So what I think employers need to do is an honest evaluation, not just of their economic exposure, but of the time and effort that it's going to take to assist your counsel in preparing for one of these cases. You mentioned insurance. There is something called employment practices liability insurance, and it's a rider to most business liability policies these days, and are often aggressively pushed by your insurance agents. And with the right policy, I would encourage you to sign on. I've seen many that have huge deductibles, a load of exclusions that make essentially coverage very limited. And and I think it's more of a boon for the insurance company and the agent who's selling it than I think it is a banner of protection for you. But with a little bit of research and a little bit of digging, I think you can find a policy that's functional. There are certainly some intentional acts that are excluded from all insurance coverage because no insurance carrier is going to underwrite intentionally bad behavior. But, you know, negligent infliction of emotional distress, you know, various things that we've talked about this morning in terms of the creation of a hostile environment, discriminatory action where an employee suffers adverse employment consequences may well trigger coverage, and you'd be wise to at least have an insurance policy, even if it does have a decent-sized deductible, because if this case evolves into a $200,000 or $400,000 damage claim, that $5,000 or $10,000 deductible is going to look like a worthwhile investment if the rest of it's picked up by your insurance coverage. Hope that I humanized it in such a way that we can all walk out of here today with the idea that we share some responsibility in making a better world and a better workplace. And if there's something that you take away from this that contributes to that cause, I'm proud of that fact. I will say one last thing about the legislation and the issue that I do find troubling, and that is I think of late we've elevated this issue to have seriousness and consequences above other acts of discrimination that are equally abhorrent. And if I was a victim of racial discrimination and I was looking at the Connecticut legislature's proposed redress to this situation, I'd be saying, well, what about me? I'm not getting a longer statute of limitations. I'm not getting punitive damages. Are you saying sexual harassment is more offensive than racial discrimination in the place of employment? I don't think so. And again, legislatures often go about their activities with the best of intentions, but don't necessarily consider all of the tangential consequences. And I think both legislatively, socially, and legally, an unintended consequence of the rise in sexual harassment awareness and claims is to minimize or devalue other bad behavior in the workplace, and we just shouldn't let that happen. So I'll leave you with that thought for today.
Thank you, Mike.
Thank you.
Thank you.